implied contract, or sometimes it will be quasi contract also. So what is express contract? If an agreement or a contract is made by words spoken or written, see, such type of contract will be called as express contract. The next one is implied contract. See, in this case, in the case of implied contract, there is no agreement in written or agreement by words spoken. This is by the circumstances or act of the parties, some kind of agreements is coming. Such kind of agreements will be called as implied agreements or implied contract. The next one is quasi contract. See, as far as quasi contract is concerned, quasi contract is not a contract at all, but by operation of law, according to section 78 etc. of the Contract Act 1872, see, some circumstances, some kind of contract will be forming. This is by operation of law. This is not by any expressed contract or implied contract. This is by operation, mainly because of to avoid the unjust enrichment of people. See, some kind of quasi contract, for example, finder of lost goods, it is his responsibility to find out the real owner and hand over the property as such. See, such kind of contracts will be called as quasi contract. The next one is an executed contract. Executed contract means this is mainly the classification on the basis of performance. On the basis of performance, the contracts may be executed contract, executory contract, or partly executed and partly executory. Executed contract means when the contractual obligations of both the parties, for example, Mr. A and B is there in a contract. See, both the parties involved in this contract, they complied their legal obligations or their duties. See, such kind of contract will be called as executed. That means the contractual obligation of both the parties involved in this contract, they completed their legal obligations. Such type of contract will be called as executed contract. The another one is executory contract. See, in this case, in case of executory contract, see, both the parties involved in this contract, they are yet to complete their obligations. It is not yet completed, so they are required to complete their obligations in the near future. And the next one is partly executed and partly executory. See, in case of partly executed and partly executory or unilateral contract, see, any one of the parties, they completed their obligations, but the other party, any other party is not yet completed his obligations. Such type of contracts are called as unilateral contract or partly executed and partly executory contract. See, these are the kinds of contract or types of contract. The next point we will discuss the rules regarding lawful offer. In order to constitute a lawful offer, what are the essential, what are the rules and regulations regarding the to constitute a valid offer? The first one is the terms of an offer should be definite or should be capable of being made definite. So first point is the terms of the offer should be definite. It should be clear. It should be definite. And both the parties, or the person to whom you are offering, that should be clear. The second one is offer should be made with an intention to create a legal relationship. Suppose you are making an offer without an intention to create any kind of legal relationship, or it might be a social offer. Such kind of offer, it will never, even though it is accepted, it will never create any kind of legal obligation. So intention to create a legal relationship is another important feature, important rules regarding a valid offer. The next one is there is no valid offer where the first one is if it is a mere statement of intention, or second one is an invitation to offer, and third one is offer must be communicated. See, these are the rules and regulations. First one is the terms of an offer should be definite, or it should be capable of being made definite. Offer should be made with an intention to create a legal relationship. The third one is there is no valid offer where if it is a mere statement of intention. The second one is it is an invitation to offer, and the fourth one is offer must be properly communicated. And regarding this a statement of price, a statement of price is not an offer. See, there is one case study called as Harvey versus Facey. See, this is 3 telegrams delivered between two parties, Harvey and Facey. The first telegram, see, will you sell us your bumper halpen? Telegraph, lowest cash price, answer paid. See, this is the telegram given by Harvey to Facey. So, first telegram, will you sell us your bumper halpen? See, bumper halpen is actually a estate in United Kingdom, and she is asking the lowest cash price. And the second telegram, the answer paid by Facey to Harvey, lowest price of bumper halpen, £900. So this is the second telegram given by Facey to Harvey. See, the third telegram is answered by Harvey to Facey, saying that we agree to buy bumper halpen in the sum of £900 asked by you. See, this is a situation. So first telegram, Harvey is asking 2 questions. Will you sell us your bumper halpen, and what is the lowest cash price? But the second telegram, Facey answered a question called as the lowest price only, but they didn't mention her agreement about or an intention about to sell that bumper halpen or that estate to Harvey. But Harvey, she accepted this offer. So in this case, there is no agreement, there is no contract, because this is only a mere intention of selling only, or there is inviting the other person to make an offer only. So this is not a valid offer, this is not a valid agreement. So this is a case study. A mere statement of price is not not an offer. The next one, offer should not contain a term the non-compliance of which would amount to acceptance. So we cannot say see silence amounts to acceptance. We cannot give any condition like the offer we will treat the acceptance in case of you are not answering this offer. And the next one is offer may be expressed or implied. See, these are the terms, these are the rules regarding the acceptance, offer of a valid offer. And the next one is offer may be a specific or general offer. See, suppose we are giving an offer to a specific person, such a type of offer will be called as a specific offer. The second one is the offer may be general one. See, general offer means suppose we are giving an offer to the public at large. Such type of offer will be called as general offer. And there is one case study regarding this general offer called as Carlyle versus Carbolic Smoke Bulb Company. See, Carbolic Smoke Bulb Company, they advertised in several newspapers that a reward of £100 would be given to any person who contracted influenza after using the smoke bulbs of the company according to its printed directions. See, the smoke bulb company, Carbolic Smoke Bulb Company is a company manufacturing some medicines. So they are offering that any person who contracted influenza after using their medicine, they will provide an a reward of £100. And what happened? Mrs. Carlyle used the smoke balls of the medicine of this company according to the directions of the company, but contracted influenza. See, in this case, see, Mrs. Carlyle is in a position to file a case against the cardboard company, or they are in a position to claim this reward of £100, because this is a general offer. Anyone, any public, anyone who is hearing or knowing this offer is in a position to accept this offer. So this is a case study regarding the general offer, and Mrs. Carlyle is in a position to claim £100. Okay, the next one, who can accept an offer? See, in case of a general offer, any public, anyone who is knowing this offer can accept it. At the same time, suppose we are talking about a specific offer, the person to whom the offer is made, only that person can accept that specific offer. General offer is concerned, any public can accept an offer. As far as a specific offer is concerned, only the specific person to whom the offer is made, such person can accept that offer. The next one, rules regarding acceptance. The first one is acceptance must be absolute and unconditional. The first important characteristic or rule of acceptance, valid acceptance, is we can say the acceptance must be absolute and unconditional. The acceptor, he is not in a position to put some conditions for accepting that offer. See, in case suppose the acceptor, he is fixing some conditions or some qualifications, such kind of offer will be treated. It will be treated only a counter offer only. It shall not be treated as a valid acceptance. The second one is acceptance must be expressed in some usual and reasonable manner. See, it should be, the acceptance should be properly communicated. See, unless and otherwise the mode of communication is specific, it should be communicated through a reasonable mode. And the third one is acceptance by performing conditions or receiving consideration only. The acceptance may be performing some conditions or receiving some consideration. A contract with an agreement without consideration is void. So consideration means something in return. So that is very, very important. See, there is one case study regarding an acceptance in ignorance of an offer is not an acceptance. An acceptance of an offer without knowing the offer is not a valid acceptance. There is one case study called as Lalman versus Gauridat. See, in this case, Gauridat sent his servant Lalman to trace his missing nephew. And Gauridat, he then announced a reward of to the person who find out his nephew. And Lalman traced the boy in ignorance of this agreement or in ignorance of this announcement. And subsequently, when he came to know about this announcement, he filed a case against his boss, claiming the reward. See, in this case, the court held that this is not a valid acceptance, because an acceptance of an offer without knowing the offer is not a valid acceptance. The next one, acceptance must be communicated. Then acceptance should be given within a stipulated time or before the offer is revoked. The acceptance should be made within a reasonable period of time or within a stipulated period of time, or the acceptance should be provided within a reasonable period or the offer just before the offer revoked. And the sixth point is where an offeree accepting an offer knowing that it had been made by the offer by mistake. So in that case, that is not a valid acceptance. Suppose the offeree, he is knowing that the offer made this offer by mistake. So in that case, that is not a valid acceptance. And see, these are the rules and regulations regarding the valid acceptance. The next one is consensus ad. There is one term called as consensus ad idem. So consensus ad idem means meeting the minds of the parties at the same time and at the same sense. Section 13 of Indian Contract 1872 defines two or more persons are said to consent when they agree upon the same thing in the same sense. So this is the term, the meaning of the term called as consensus item. The next one is communication. Section 4 of the Contract Act is related to communication of offer and acceptance. So communication is the most important. Without communicating the offer and acceptance, it shall not be treated as a valid offer or valid acceptance. So suppose we are talking about contracts through post. Communication of proposal is complete when it comes to the knowledge of the person to whom it is made. As far as offer is concerned or proposal is concerned, the communication of proposal is complete if the person to whom the communication is or offer is made, when he comes to know regarding this offer, so in that case we can say that communication is completed. The second one, communication of an acceptance is complete as against the proposer when it is put into the course of transmission to him. So suppose we are sending communication through post. See, whenever the acceptor, he is preparing a letter and inserting that letter into the letter box. See, in that case, that time we can say that communication is completed, because it is a responsibility of the postal department to remit that or deliver that letter to the right person. Suppose as far as an acceptor is concerned, suppose he prepared that letter and he quoted the correct address and all, and whenever he putting that letter in the course of transmission, see, in that case we can say that communication of acceptance is complete. And against an acceptor when it comes to the knowledge of the proposer. See, these are the rules and regulations regarding communication. And suppose we are talking about revocation. Revocation is possible. The proposer, the offerer, he is in a position to revoke or withdraw his offer at any point of time. So what are the rules regarding the revocation of an offer? A proposal may be revoked at any time before the communication of acceptance is complete. So at any time before the communication of acceptance complete, the offerer, he is in a position to revoke it. And after getting this communication of acceptance, the offerer, he is not in a position to revoke the offer. See, these are the rules and regulations regarding offer and acceptance. With this, first lesson is over. The second lesson, we will start the second lesson. The second lesson is called as consideration and acceptance of contract. Okay, welcome back to our discussion about the contract at 1872. So we will start with the lesson 2, consideration and competence to contract. So in this chapter we will discuss the rules and regulations regarding the consideration, definition about consideration, rules and regulations about valid consideration. Similarly, competency to enter into a contract. So here we will first of all we will discuss with the definition of consideration. Section 2 subsection D of the Indian Contract at 1872 defines what is consideration. According to section 2 subsection D, consideration means when the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something. Such act, promise or abstinence is called as consideration for the promise. This is the definition given by the contract at 1872. So according to section 2 subsection D, consideration means when the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something. Such act, abstinence or promise is called as consideration for a promise. So if we go through this definition, we can see a consideration might be past, present or future. It might be an act to do or not to do something, or abstain from doing something. It might be moved from the promisee or any other third person. That means any other person. Even third party consideration is also valid. An agreement without consideration is void. So every agreement should, in order to constitute a valid agreement or valid contract, it should be supported by a valid consideration. No consideration, no contract. So if there is no consideration in a contract, there is no contract at all. And let's see that there is one case study regarding the consideration called as Abdulaziz versus Masum Ali. See, in this case, the secretary of a mosque committee filed a suit to enforce a promise which the promisor had made to subscribe 500 to the rebuilding of a mosque. Held promise was not enforceable because there was no consideration in the sense of benefit, as the person who made the promise gained nothing in return to the promise made, and the secretary of the committee to whom the promise made suffered no detriment at all. So in that case, there is no valid consideration. At the same time, suppose the secretary of the mosque committee, after receiving this promise or after accepting this promise, maybe he made some sort of commitment and he caused some kind of detriment. So in that case, such a contract is valid, or that agreement is valid. See, this is a case study regarding the consideration. And another case study called as Kedarnath versus Gauri Muhammad. See, in this case, Gauri Muhammad promised to subscribe rupees 1,000 for the construction of a town hall, and on the faith of the promise, Kedarnath had undertaken certain liabilities, and later on Gauri Muhammad, he declined his promise. And in this case, this contract is, or this agreement is valid, and the Kedarnath is in a position to enforce this contract, because mainly because of the promise given by Gauri Muhammad, Kedarnath, he committed some liabilities. In that case, that liability, that detriment will be treated as a valid consideration, and this is an enforceable agreement. And what are the next topic is, what are the essentials of a valid consideration? The first point is, consideration must move at the desire of the promisor. The consideration must move at the desire of the promisor, and there is one case study, Durga Prasad versus Baldio, that you will see later. And the second point is, the consideration may move from the promisee or from any other person on behalf of the promisee. So that means consideration may move from the promisee or any other third person on behalf of the promisee, and even third party consideration is valid. The next one, consideration may be past, present, or future. The past